If you're not in a will and you believe you should be, then your only recourse is to object to a will. Now, normally, I don't, if you come to see me and say, hey, I think there's an issue with regard to my father's will, I don't normally say, well, we're going to file objections right away. One of the things that you are absolutely entitled to is an examination of witnesses, and if not, and the drafter. And this is very useful. So you can go to court when the time comes and when the will is in front of the judge, whether it's good or bad, and say, I want to examine the witnesses, and that's called a 1404 examination. And the drafter, if it is that the drafter was not a witness. And that's very useful because then you can have your attorney go, these people are brought in, and you can find the circumstances of this will. You can find out what happened. How did this person come to the attorney? Who brought to this person? Who was there when the will was signed? Was the person in a hospital room, 3 days before death, or was the person in their home doing crossword puzzles, the New York Times crossword puzzles? I mean, you can find all this information as to it. You can also, if you'd like, again, it depends on how much effort and assets you want to put into this, is obtain what's called discovery before the examination, which means you can go to the, get medical records, get asset records, bank records, and things like that to find out what's going on with this person. So generally, you gather this information, you have this examination, and at that point you can make a determination whether you want to object to this will. The court will say, all right, you got 2 or 3 weeks, file your objections. And again, there's only a few grounds for objections. Is the person incapacitated? Well, in that case, you're going to have medical testimony saying that the person at the date of the will, not after, the date of the will was not able to handle their affairs, didn't understand the nature of their assets, didn't understand their what they call objects of their bounty, their family. The person was not affected. So you have to make that claim. And again, you do that by medical records, testimony, expert testimony, doctors, that type of thing. Second, you could make a claim that the person was undue influenced by someone. Very, very difficult to make this claim because usually undue influences occurs in a room with a person and a decedent. People do not go around after they've done a will saying to other people, well, my son forced me to do this will. It could happen, but it hasn't happened to me. So if the son forced a person to do the will, he generally has done it in the living room with the decedent and only the son present. So, but can you make a case for it? Yeah, I suppose, if the facts are right. You can make a case that there was a mistake of fact, that the person just didn't understand he had 3 kids. Kind of goes to incapacity. And then there was something wrong with the will procedure. Maybe the person didn't sign the will, or he didn't tell the people that he was signing a will. I'm aware of cases where the witnesses didn't know that the person was signing the will. He said, here, sign this. And they didn't actually see the person sign the will. He put the witness statement in front of them and they signed it. I mean, if that happens, then yeah, you can make that argument. But generally speaking, very difficult, but the facts are right. You can object and see what happens.